But the worst case scenario is that on September 30th, she would have to report herself to Congress and say that I've had this decision pending longer than 6 months.
In today's video, Attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon.
It's one of those situations where you're asked a question, you give an answer, and then people try to pigeonhole you. Basically, all I said is that if you look at her previous decisions, there was a case where she gave the decision for summary judgment at the very same time as the Daubert expert motion. There was a case that she did it 30 days later, 60 days later, 4 months later, and then there was a case that was 6 months later. So all I said is if you average it out, usually 60 days from the Daubert decision, you get a ruling. So I said I would be surprised, a bit surprised if we don't have a ruling by May 6th, but not shocked. So I sit here saying, I'm surprised that we don't have a ruling, okay? But I'm not shocked. You know, here's the thing. Everybody wants to know worst case scenario. And, you know, I didn't mean it to be like this monumental prediction in any way, but the worst case scenario is that on September 30th, she would have to report herself to Congress and say that I've had this decision pending longer than 6 months. It's been this long. And she has avoided that in the past, that she's never been on that list. Judges look at that list as a list of shame. If they're on, they have to say to Congress, look, I've had this decision on this important case and it's been 8 months. If they have any kind of aspirations to be an appellate justice, to be a Supreme Court justice, they try to stay off that list. So she would have to do that. So if you're looking for what's the absolute worst, it would be the 29th of September. I think we're going to get it any day from now to August, but we'll see. Think about this judge. No case in history has tens of thousands of individual holders come to the court and said, we feel so strong about this, we want to be sued as defendants too, because you really have sued us anyways, you might as well make it official. That's massive. How many decisions does a judge make that actually will impact the trajectory of global trade and finance in the United States? So it's a pretty big decision, and she knows all eyes are on her. And so I wouldn't be surprised if she's written it and she's just sitting there parsing word after word, trying to make sure, knowing that it could go on appeal, it could be before the Supreme Court, or just the public interest that this case has. Yeah. The reason why I'm on this stage right now, had the SEC done what it's supposed to do and say, Ripple, the specific company, on this specific day, when you gave an option contract for 1 billion XRP at 6 cents or whatever, on that particular day, we find that to be an investment contract. Or when you did this on this day, and they give specific transactions and they limit it to that, right? Because beavers have been sold as an investment contract, orange groves, chinchillas, whiskey, condos. The underlying asset itself is never the issue, right? Bitcoin in 2013 and SEC v. Shavers was packaged as an investment contract, but they didn't turn around and say Bitcoin itself was a security. But the SEC complaint implied that, and then when we got involved, they then went ahead and said even secondary market sales represent the investment contract. And so that's why it was so important for XRP holders to do what they did, because we're saying to the judge, listen, if Ripple broke the law, whether we agree with it or not, that's Ripple, right? And they'll be okay. And but these individuals who are using the ledger, using the DEX, or investing, doesn't matter, you can't say they're an investment contract. 52% of XRP holders that I've dealt with and tallied who signed affidavits stated that when they knew the word Ripple because XRP and Ripple were used interchangeably.
Ripple coin on most exchanges.
But 52% of first-time purchasers of XRP did not know of a company called Ripple that sold software to banks. Jay from Spin the Bits, he's the smartest they come. The first time he bought XRP, he did not know about this company Ripple. And so that's what we're getting at. And so that's why we have to fight. And that's why in the library case, I went in on behalf of Naomi Brockwell to say to the judge, and the judge, he hasn't done the order yet, but he made a great example on record. We have the transcript where he said, look, when library sold to Flipside Crypto, who put it in cold storage, that was an investment contract. But when Flipside sells it thereafter, that doesn't mean it's an investment contract. And so that's the fight. And that's why everybody who's been a part of this case, even if you didn't sign the case, your support has been monumental. Know that we got that bullshit expert excluded, right? You all did that. We did that. The guy who was going to testify as to what you and I thought the day we acquired XRP, the judge said, no, you don't get to do that. And so we have had an impact. Why the SEC chose that path? If Jeremy was in charge of the SEC, he would have said, ignore the guy on Twitter, right? We're not going to file a motion to throw him off the case and claim that he threatened Jay Clayton to beat his ass and all this nonsense. We're not going to do that. Just ignore the dude. If he files something and we want to respond to it, we will. But instead, because they fear you, right? They fear the message, they decided to, get their feelings all hurt. I think that around the same time when it comes down, I think that Rosalind Layton's motion where they intervened to gain access to that puts added pressure on her. I think we're eventually going to see it. So we'll get to see, as I think it was Brad Garlinghouse who said that we'll be shocked. We won't be shocked. Maybe the rest of the world will be shocked because we all know that this lawsuit was a weapon. On January 1st, 9 days after the lawsuit in the writ of mandamus, I literally wrote, the only explanation that this makes is that this lawsuit was used as a weapon for some reason. Didn't know the reason then, didn't know about the EEA and Simpson Thatcher and Hinman was getting 15 million at the time, didn't know all that, but we were able to say that it was used as a weapon. So I think we'll get it eventually. It's not just the Hinman emails. Remember, DAI's done a great job of making people aware of this. Remember, it's all the other emails that Empower Oversight, that watchdog, right, group. We want to know what the emails were, not just from Simpson Thatcher and Bill Hinman, but the emails to Joe Lubin, the emails to Consensus Lawyers, and all those other emails.
Right.
Imagine what we look what we learned from just the Simpson Thatcher email. Imagine if we get Hinman's Google email. What might that say? It also made perfect sense to me, and I know that Digital Asset Investor, when I said this, he agreed. It made perfect sense to settle the case, right? Get Ripple to pay. Ripple would, even though you might not believe this, I'm pretty confident that they said, we'll bless all ongoing and future sales of XRP, pay us $250 million for early sales. I think Brad Garlinghouse would have wrote the check immediately with that kind of certainty. And you could go then to Gary Gensler could say, look, I got one of the highest settlements in history, and then be able to still go after all these other crypto projects. So that made perfect sense, but that's not what's happened. And I think Gary Gensler is such a megalomaniac who thinks that he's always right. I don't rule it out. I think that they would file a notice of appeal just to preserve it and then try to see if they can negotiate a settlement, right? And so the only guarantee of an appeal is if Ripple loses, right? That's the only guarantee. Then it could get to the Supreme Court. But I would normally just agree with Jeremy 100%, but when you're dealing with a guy like Gary Gensler, you just don't know. Because listen, Library CEO told us from the beginning, come in, Ripple actually was the first. If you look at the actual facts and you look at actual history, Ripple met with the SEC In fact, it's the famous meeting that they met in 2018, in August of 2018. We've got the Hinman speech in June, says ETH and Bitcoin are blessed, right? And so Ripple's meeting with them, within 2 months, Ripple's meeting with them. They do not say to Ripple, XRP is a security. That's the meeting that Brad Garlinghouse actually spoke up, and we got the notes to prove it. Brad Garlinghouse says, Ripple's living in purgatory. You blessed ETH and Bitcoin. We're the third largest, we have the third largest crypto asset in the world. What about XRP? They don't respond because it's a security. If you look at the actual deposition of Hinman, they say, Chairman Clayton says, oh, well, that's neither here nor there now. We'll keep talking to us. Talk to us about the technology. Right? And David Schwartz was there. So all that was a farce and a ruse to learn everything they could to sue him. Mm-hmm. Right? And it's the same thing that happened to Library. They sat there, Jeremy Kauffman had a PowerPoint presentation where he went line by line of the Hinman speech with the Library platform and said, look, we are even more sufficiently decentralized than Ethereum. Therefore, and all they did is take all that information, cost them $4 million in investigation costs, then sue them and cost them another $2 million. Mm-hmm. So it's all nonsense. And what Jeremy's saying about this, think about this. How do you register a line of software code, right? A line of code existing in software that's in cyberspace? I mean, you just can't do it. I know I just sounded like that dude from MicroStrategy, didn't I? Like cyberspace energy, it's energy.
You had a great op-ed on that recently.
Yeah, no, but that's the point. Jeremy's saying you can't. It's nonsense. I mean, Gary Gensler literally said we have a form on our website. Mm-hmm. That's after Kraken paid the $30 million. They paid the ransom. And then they said, we're going to leave the United States. We're going to stop offering this yield product, right? So I think there was a comment just now is that they're corrupt. What we need to do at the SEC is this. You know how there's this bill in Congress that these politicians shouldn't be allowed to make trades because they have insider information? The first thing we need to do at the SEC and the FDA and the EPA is have a rule that you're not allowed to go work for who you just regulated within 3 years, right? That's what you need. Then, because think about this, just think about this. If Stuart Alderodi would have hired Jay Clayton's firm, Sullivan and Cromwell, immediately when he was nominated, like Joe Lubin did, Clayton would have been preempted. He would have had to recuse himself, right? Oh, my firm represents Ripple. I can't vote for this enforcement action. I mean, that can't be the system that we live under. Where you had Dugan Bliss, who was a prosecutor in the Ripple case, and he leaves in the middle of the case and goes to BlockFi. I mean, you just can't have that kind of incestuous kind of, system. And so that's what we need to do.
Revolving door, I think they call it on Wall Street, but saving.
Yeah, I mean, here's the problem is your boss, Charlie Gasparino, right, says, well, John, that a lot of that Hinman stuff, that's just the way it is. Well, F that, man. That's not the way it's supposed to be.